We are awaiting the verdict in the so-called loud music murder trial. Jury deliberations stretching into a fourth day now. Michael Dunn, accused of shooting and killing a Florida teenager. He says he was acting in self-defense, but prosecutors say that 17-year-old Jordan Davis never stood a chance against Dunn. Steve Harrigan is covering it live from Miami. Steve?
Greg, on this day 4 of deliberations, the jury had more questions for the judge this morning, asking if all the charges against Dunn should be considered separately. Dunn is facing, of course, a first-degree murder charge for murdering a 17-year-old African-American. He also faces lesser charges of attempted murder for firing into a vehicle where there were 3 other young men present. Those attempted murder charges carry a penalty of up to 20 years each. Throughout this case, the defense has maintained that Dunn was simply acting in self-defense. He claims to have seen a rifle pointed at him. No weapon was found at the police at any time after the shooting took place. The prosecution says Dunn acted with deliberation, that he fired 10 shots in all, including 3 shots that they say happened when the SUV containing all 4 passengers was already pulling away. Now, that courtroom is cleared now. We are waiting for the jury's verdict or to see if they can reach a verdict now in day 4 of deliberation. Greg, back to you.
All right, Steve Harrigan, we may be coming back to you any moment now if there's a verdict, so thanks very much for the update. Jamie?
All right, let's bring in our legal panel on this. Robert Schalk is a defense attorney and former prosecutor. Alex Little joining me as well, defense attorney, former assistant federal prosecutor. Gentlemen, welcome.
Hi, Jamie.
Alex, let me start with you. This is really a self-defense case. Florida has stand your ground, but no matter how you look at it, the facts have to prove that the defendant had an imminent and reasonable belief that his life was in danger. Have they met the standard in Florida in this case, from what you've heard?
I don't think so, and I don't think watching the trial they would have even got the instruction for self-defense until Michael Dunn himself took the stand and suggested that he had seen what he believed was a shotgun. I don't think the evidence was very credible. The rest of the evidence, the weight of the evidence, really weighs against that. But self-defense cases are incredibly difficult because the instructions are complex, and I think jurors tend to think of themselves more in the place of the defendant in a self-defense case than in any other time, because you wonder what you would do in a similar situation. And you've got 12 people in there. You've got to convince all 12 beyond a reasonable doubt that he didn't act in self-defense, and that can be very difficult to do.
You know, at the same time, Robert, a 17-year-old is dead, and he does make the claim, the defendant, that he saw a shotgun, but no one can corroborate it.
Yeah, that's a huge problem for the defense in the sense that he's saying he saw a gun and there's not one witness, his girlfriend or anyone. The most important part is, even when his girlfriend testified, she said he never mentioned it to her when minutes afterwards. So that's a huge hurdle that the defense has, I don't think, been able to get over. And not only that, their other argument is that the Durango left the scene for a short period of time. They could have dumped it. I really don't think the jury's going to focus on that. I think it comes down to whether or not they believe Michael Dunn, flat out. If they believe him, he may get, he get acquitted, maybe get a lesser included charge, one of the manslaughter charges.
Right.
But again, the physical evidence is on the side of the prosecution in this case, as Alex said earlier.
Well, let's talk about that, Alex, because it's interesting. In this particular jury instruction, the judge included a lot of lesser offenses. It's not that he said to them, you must find first-degree murder. He included a lot of other reasons that they could find him guilty. And it's interesting that the jury came back with the question that they came back with once they started deliberating, saying, can we find guilty on one charge and not on another, or not guilty on one charge and guilty on another? What does that tell you?
Well, I think what they're probably focusing on, and I will say as a caveat, you never know what the jury's thinking when they ask questions.
You're right.
It could be a question that one person has, it could be everybody, so we could be completely off base. But if I'm in the courtroom and I hear that question about self-defense and whether we should consider it separately with some charges and others, there was no evidence whatsoever that Michael Dunn had seen anything to suggest that the other people in that car, the other 3 individuals, had a gun, had a weapon, posed any threat to him whatsoever. So I could see them very easily trying to take some of these charges off the table and agree on them quickly and say, you know what, there's no evidence that those folks were a danger. He's guilty of all the attempted murder charges, and then focus solely on the murder charge against Jordan Davis as a place where they may have some concerns about whether or not it's first-degree, second-degree manslaughter, or some version of self-defense. That's probably what's going on.
Robert, for some of our viewers who maybe aren't following the case as closely as the four lawyers that we have here are, it is interesting that he made a comment to his girlfriend about the loud music and the fact that he was disturbed by it. It is interesting to me also, and I never considered this in a self-defense case, though I have studied extensively Stand Your Ground. I'm a Florida lawyer as well, that he had a gun, possessed a gun in the glove box. How does that impact his reasonable belief, Robert, of being in fear for his life when he knows he's got a loaded gun in the car?
Exactly. He's carrying a loaded weapon. He's had it for 20 years. And not only that, you have a situation where Michael Dunn has a car and can get in his car and drive away. This is, the parallel that everyone wants to make it the comparison to is the George Zimmerman case. George Zimmerman had physical injuries that everyone can see he suffered. In this case, Michael Dunn has no injuries, no witnesses, and he had a gun and a car, but he had the opportunity to leave that situation. It appears by everything that I've seen that he was obviously the one who escalated this situation with his decision to go back to his car, get the gun, and discharge those bullets.
That's a decision the jury's going to have to make, and it's a tough one, but it is relevant, I believe, that Alex, that he left the scene.
Sure.
The shooting happened, and the defendant leaves and drives off and then wants to turn himself into a completely different police district, closer, where he thought he could tell his side of the story. He took the stand.
Absolutely. He doesn't call 911, yeah.
What about that, Alex, that he took the stand, something that Zimmerman didn't do?
Well, I think he had to take the stand because there was no evidence. His girlfriend's testimony, or I guess the fiance, gave no basis whatsoever for a self-defense instruction. So if anybody was going to say that he felt under threat, the only person that could do that was Michael Dunn. And he was really in the place where without that opportunity to take the stand, he had no chance. He set himself up for some very strong cross-examination. I think a lot of the stuff that he said on the stand didn't hold up. He talked about the music you mentioned and said very different things than the fiance who was in the car with him. But I think he had to do it. I think the jury is now trying to grapple with, gosh, did you believe him? Did you not believe him? That's very, very difficult for a jury to do, to disbelieve someone beyond reasonable doubt, which, because we're talking about self-defense, is what the state's going to have to prove.
Yeah, and they're both, it seems like both sides on this case are fighting vigorously for their side of the case. And you guys did a great job, too. Really appreciate it. And, folks, this verdict could come in at any moment. We certainly will bring it to you when it does. Thank you so much, Alex and Robert. Greg?
Your point about fleeing the scene. Often there's a jury instruction that flight is evidence of consciousness of guilt. Sometimes you don't even need the jury instruction because jurors intuitively know that.
I never thought about it in a self-defense case, though. I wasn't a criminal attorney, but having a gun in the glove box should give you some sense of less of a need for self-defense, but I don't know.
Well, and it might undermine the argument of voluntary manslaughter, which in Florida is heat of passion, sudden impulse. A lot less punishment than murder.
Yep, we'll have to see what happens. Could it be today?
It's advertised.